can a court determine the religious character now of Hindu festivals? Because what we saw the High Court kind of doing was to suggest that this is a cultural event. That's exactly what the Karnataka government said. This is not something that is inveiled with religion in any level. So I want to ask you, yes, we've had determinations now of the religious character of Hindu place of worship, but now is this going to extend by logic to determining the religious character of Hindu festivals? Can that happen in a secular country?
See, Rahul, let me begin by saying that yesterday on your show, when we were discussing about the fault lines, when we were discussing about this issue, I had highlighted that the main difficulty is the principle of secularism, which has been included in the preamble. And today's hearing, if you will see what transpired was the Honorable Court asked that what is written in our preamble? The council replied that secularism is written, all right, dismissed. Actually, there was no hearing. So the point is this, that when we went to the Supreme Court under Article 32 and said that these two constitutional amendments, which have been made by 42nd Amendment in 1976, is completely erroneous. It is against the theme of the preamble. And one of the honorable judges of the Supreme Court was of the view that this constitutional preamble comes with a cutoff date, 26 November 1949. So this constitutional preamble cannot be amended. But ultimately, without any hearing, that petition was rejected. And today we are in a constitutional situation where all our demands are rejected on the basis of the principles of secularism. Supreme Court in S.R. Bomai's case has reiterated that secularism is the basic structure of the constitution. But when we come up with a debate that please tell us what is the true meaning of secularism, there is no discussion. There are petitions filed in the Supreme Court, Rahul, where the demand was that please define the word secularism. That has also been rejected. So on a very vague principle, the things are being rejected, and the constitutional norm which was set up in Shirur Mutt's case in 1954 is not being followed. I'm very much in tune with what Mr. Kanchan is saying and what my dear senior Mr. Anand Rangnathan is saying. And let me give you certain examples. So far as Supreme Court is concerned, so far as WAF hearing was concerned, we are celebrating today the order of WAF, which I feel is not a matter of celebration. There was no hearing on the WAF Act 1995. No hearing at all. The original act, there was no hearing. Apart from that, the Supreme Court has examined the validity of Jallikattu. The Supreme Court has examined the validity of height of Dahi Handi. Dahi Handi की height कितनी हो? इस पे पूरा एक अच्छे से hearing हुआ है सुप्रीम कोर्ट में. जगन्नाथपुरी रथ यात्रा was stalled during COVID times. Later on, because of uproar, it was restored.